I'm Matt Gishard, and this is No Holds Barred. Today we're going to have a chat about cannabis, otherwise known as marijuana. And we're pleased to have here Bryan Bergman with the law firm Nolan Heimann, and he is an expert in the area that we're going to talk about here today. And before we get started, Bryan, just tell us a little bit about you and how you got started in this particular area of law.
Thanks, Matt, and happy to be here today. I appreciate it. Fun to be a part of this and talk about these issues. So yes, my name is Bryan Bergman. I am a partner with Nolan Heimann, LLP, which is mainly based out of Southern California, but we have offices throughout the United States. We are a monetizing and cross-collateralizing law firm. And what that really means is that we help to businesses in a variety of verticals come up with authentic and bespoke strategies to help them not only get traditional business transactional work and operations taken care of from a legal perspective, but also to utilize what they're already doing to authentically find new ways to make money and make new deals across other industries, because we are unique in the types of expertise we have. For instance, I head up the cannabis practice area, and I'm also a key member in the corporate group at the firm, and do a lot of deal making and work across a variety of industries, and of course lead the charge for the cannabis practices. One of our favorite things that we're working on right now is what we're calling the potent initiative, which is the intersection of out-of-home cannabis, or pot, and entertainment out of home, or ENT. So pot and potent. That's where we came up with that. And we're very excited to see all the unique opportunities that are coming up for the industry, working with other non-plant touching industries as they find ways to monetize and create new opportunities for embracing the lifestyle of cannabis out of home with other markets and other types of businesses. So that's really exciting, and it's something I've been working with the industry operators and investors for, and ancillary providers for, I don't know, it's only been about 7 or 8 years, but those are dog years in my head, so I would say it feels more like 50 in my mind. And I've been very excited to be doing that. I regularly teach continuing legal education on cannabis issues for a variety of matters, and am also on the executive board of the Los Angeles County Bar Association's cannabis section and their policy. So that's me in a nutshell, and I'm happy to be here today, Matt. Thanks for having me.
Wow, that's impressive. It's very impressive. Happy to have you here, and we're going to specifically talk about, although you have lots and lots of expertise in lots of areas, we're going to talk about cannabis today. And, really, I'd like to kind of preface our remarks with, people have lots of different ideas about cannabis, whether they agree with it, whether they don't know. That's not what we're going to talk about today. We're going to talk about, it is the law in the state of California, and I want to talk about that. And so what I'd really like to do is just start off with the overview of the marijuana industry in 2023. Why don't you just tell us basically about that?
Sure. Well, it's still federally illegal. And what that means is it's still considered a Schedule 1 controlled substance. There's 5 different categories of schedules in the Federal Controlled Substances Act, and basically it goes from 1 to 5. And Schedule 1 is the most dangerous substances that the federal government is aware of, and when they're Schedule 1, they're deemed to be not really of any medical benefit. They're very easy to be used in an abusive fashion, and there just doesn't seem to be really any positive use in those types of Schedule 1 substances. So that would be something like heroin, or or maybe it would be PCP. And apparently, according to the federal government, it's also cannabis. Whereas Schedule 2, which is a little less regulated but still kind of dangerous, has cocaine and LSD. So according to the federal government, cannabis is more dangerous medically and otherwise, and has no medical use, than even cocaine or LSD, which I've always found to be very interesting. Because of this illegality, which I'm not going to get into in too much detail right now, if you're engaged in interstate, across state commerce, that's a problem. If you're doing something according to federal law on federal land, it's still illegal. And so what that does is it creates some real roadblocks for the growth of the industry. However, the Controlled Substances Act of the federal government in the United States actually provides that it can't preempt state laws unless there is something that the state is doing that would in some way affect interstate commerce. And what that basically means is there's nothing stopping states from within their own borders having laws about the use and consumption of cannabis. And that's what we've been seeing is this dichotomy is that many states have voted over 30 more than half have now voted that there are medical uses for cannabis or some form of cannabinoids such as CBD in one form or another. And so they have allowed for either medical or recreational use within those states. So it gets a little confusing because we have these situations where it might be legal in one state or another, but not federally. And so it becomes very important for operators to understand how they can actually engage in commerce with cannabis as a plant touching business in each state that it's in, and that it complies with those laws and doesn't leave that state. And so
let's talk
that is
about
something
that
that
then.
really comes into play.
Yeah. So the confusing
Pardon?
part, what we're going to try to do today is make it a little less confusing. So let's talk about
Sure.
California. There was a proposition and it passed. It was 64,
Yeah.
wasn't it? Proposition 64. Tell us about that, because in California, then a majority of the population voted to legalize recreational marijuana. Tell us a little
Right.
bit
And
about
before
that
that, we
one.
had medical since 96.
Hmm.
And since that, we've now had recreational in one form or another since 2016, although it took until 2018 or so for regulations to get appointed. So here in California today, there is a robust, and some would say more than needed, amount of regulations in place for allowing over 13 different types of licenses across the supply chain. So you could be a producer, which would be either someone that cultivates or grows the plant. You could be a manufacturer or somebody who takes that plant and breaks it down into another form, whether it's an extracted oil or infused into some sort of food as an edible or a drink or otherwise. And then you also have different license types for moving it around and transporting it across the supply chain, which is distribution and taking care of quality control. And then they have retail licenses, which are for selling it to the end consumer or patients. And then there's also micro business which is a combination of licenses, temporary licenses as well for events. And finally, there's also a license for testing, which is its own separate lab testing to make sure for public safety that there's different testing in place to make sure that everything that's out there is safe for human consumption and animal consumption in some limited respects as well. And so there's license types for each of those activities out there, and depending on what the business wants to do, you have to be able to comply both with the law of the city or county that you're in, as well as get the state license. So it's not only figuring out how to comply with state law, it's also complying with the law where your business is located. So it can be pretty Byzantine in how it lays out, but there is a way to do it. When you talk about the state of the industry right now, Matt, it's interesting. There's plenty of businesses out there, but there's been unequal enforcement, and sometimes it's up, sometimes it's down on illegal and illicit businesses, and sometimes there's tax issues. And because of the federal illegality and the issues with banking and taxation of what is deemed to be a federally illegal business, there's a lot of hurdles that these businesses face that they need to be fully aware of before they decide to open a business, because people think it's easy to run a cannabis business. That could not be a further fallacy. It is probably one of the hardest businesses to run in the country right now.
Yeah, I'm going to talk about as we go a lot of those things you talked about, the banking issues, the safety issues. Actually, before you mentioned a little testing license, and I want to talk about that. But first and foremost, I do want
Sure.
to say citizens voted for it, but we don't have it. And that's interesting that many people say, I voted for it, but not in my backyard or not in my neighborhood. So the licensing within cities, even though statewide. So tell us a little bit about how would somebody
Sure.
go about opening up in their city a retail establishment? What requirements are there?
Well, for starters, a good place to know is that all of California has what's called permissive use zoning laws throughout its country, throughout the state, and therefore throughout each city and county within it. And what that means is if it doesn't list it on a zoning as a admissible activity, you can't do it. So local, and zoning is done by local government. So every local government has to decide under Prop 64 whether to regulate or ban the activity in full. There's no other in between. You can't just pretend to not worry about it and look the other way. Each local jurisdiction has to regulate or ban it. If they choose, so the first thing you want to do is you want to look at where you want to open your business. Then you have to look at the local rules and regulations for allowing or if it's banned. Assuming it's allowed, what are the rules for getting a license, and do you need special land use permissions, typically known as CUPs or conditional use permits, if it's not openly zoned as such. So you have to work through the laws of your local government to make sure that not only do they allow for retail licensing like you asked, but where in their jurisdiction are you allowed to do them and what rules apply. And you have to go and get local permissions, because when you apply to the state level, the first thing they're going to do after they get your application is check with the local government to make sure that you are in compliance with their rules and regulations. So it's a process to figure out first what the local rules are and then be in compliance with those before you apply to the state for the state license. The state license is just a matter of checking the boxes and providing the information. Each local government has a decision whether they want to do it merit-based, meaning that you have to apply for and give something like a request for proposal or something similar, an application that they want to have you in there, and they only give a limited number of permissions out. Or the larger cities such as Los Angeles, Long Beach, maybe San Francisco or Oakland, they just maybe don't have a merit-based structure, but there's still rules and regulations for how you get a license. And so it's very important to understand the regulatory process in your city where you want to run and do your business. And if they don't allow it, you have to work with your regulators to get them to allow it.
We see a lot of cities that I'm told don't allow it, but they allow delivery. Mm-hmm. So how does delivery work? How does that in terms of permitting?
This has been an interesting hot topic because it was originally intended by the cities and legislators before Prop 64 passed that you had to actually have permission to operate within each local jurisdiction. But because of the language of Prop 64 and some of the rules that pass, one of the laws says that like no local jurisdiction can prevent cannabis businesses, even if they ban cannabis businesses from traversing on publicly accessible roads through their jurisdiction. And so what that means is with delivery is that even if they don't allow delivery within their city or county limits, that neighboring licensees from permissible areas are still able to deliver into those limits because of that lack of restriction, and also because it's incredibly difficult to police. And so even if there is a law in the books, how do you enforce that law? So that's why we're seeing a lot of delivery coming into jurisdictions that don't allow it. More and more are coming online, but there are still what we call cannabis deserts throughout the middle of California, where you see large swaths of land where there are no permissible cannabis businesses allowed still. And that's something that is really a matter of the will of the citizens within that city or county and how much they are working and educating their officials and what the appetite is in each individual city or county.
Thank you for watching this episode on cannabis. If you have any comments, please leave them below. And we look forward to seeing you on future episodes of No Holds Barred. Be sure to like and subscribe because it helps us with our YouTube algorithm.